So in this workshop, we are going to address two main issues. That's the result from an empirical study that we conducted not so long ago. And then also we will share some experience from the field. This workshop will be given by Johannes Sil and myself. I will briefly introduce Johannes and myself. So Johannes is a lawyer and accredited mediator in Belgium, and I'm assistant professor and postdoctoral researcher at the University of Antwerp. So I will explain briefly how we proceed with this workshop. It will consist of two parts. In the first part, I will elaborate on some key results of the survey on dispute resolution culture in Belgium. And in the second part, Johannes will take the lead and will share some experience from the field. And in between two parts, we are planning to have a short break of some 15 minutes. All right, so going to the part number one, the survey. So here is an outline of the first part. The exact title of a study that we conducted is Barometer of Dispute Resolution in Belgium, Residents' Attitudes to and Experiences with Handling Disputes. So I will provide an overview of the survey's goal and structure. Then we'll look at the participants of the survey, and then I will share some preliminary results. In terms of the goal and structure. So this survey was conducted in September 2022, and it was designed by the team of researchers at the University of Antwerp and Conflicool. Johannes later on in the second part of this workshop would introduce properly Conflicool, but I can briefly say that it's a non-profit organization dedicated to the amicable resolution of disputes. So, and in our survey, we aimed to gather data from the Belgian residents about two main things. So, on the one hand, we were interested to learn about the attitudes of the Belgian residents to various ways of handling disputes. And on the other hand, we were interested on the actual experiences with handling disputes, if they had any over the last 3 years. And our focus was on private disputes only. So we were not interested in disputes that people experience as entrepreneurs or disputes that were experienced by employers of people. So only private disputes. And then in line with the goal of our survey, we had the following structure. So our survey was divided into two parts, and there were 27 questions. In the first part, we gave it information about the attitudes to ways of handling disputes. And in the second part, we collected data on the actual experiences of our participants with handling disputes, indeed, if they had any experience. And our survey is an example of a legal needs survey. So these are surveys that investigate the experience of problems from the perspective of those who actually face them. It's a bottom-up perspective, rather than from that of justice professionals or institutions, which is a top-down perspective. And in designing our survey, we tried to adhere as much as possible to best practices. So in particular, there is evidence that public understanding of law is quite low, and legal concepts are often very narrowly construed. So, and the emphasis is mostly placed on criminal justice. So, and good practice is not to frame surveys around legal problems or by referring to law in general, because this may limit responses to those where there was a reliance on some legal services. So good practice is to avoid reference to law, and instead it's best to describe the subject matter in lay terms. And that's what we did. So our survey contained a generic reference to problems and disputes that people commonly experience in everyday life. And we accompanied that description by examples. So these were the examples: being unfairly dismissed or injured at work, or getting divorced. Now I'm moving to the section on participants. And here I need to mention that our survey was administered by YouGov, and that's a London-based market research company. So the participants were randomly sampled from the proprietary panel of YouGov in Belgium that is made up of approximately 19,000 Belgian residents. And the composition of the sample included quotas for age, gender, geographical distribution, and level of education. The survey was uploaded on the YouGov surveying platform, and then participants were invited to take part in the survey via email or mobile application. And as a result, we had 2,005 participants in our survey, and our participants are balanced in terms of age, gender, geographical distribution, and level of education. And you can see, so here I put some charts. So we have different age groups represented. We have males and females. We have representatives of different regions within Belgium, and also different levels of education. Now I will move to the section on preliminary results, because probably this is the most interesting part of the survey. So in our survey, so far, what we try to do, we try to analyze most of the results of our survey. We try to put them in the context, find links to other relevant studies, and sometimes we had to pose some questions because we were not sure why we had the result that we received. And so I would like to just say a word of caution that what I'm going to tell today, it represents the initial analysis of results, and perhaps if we look deeper into the data, some new insights will emerge. So again, in presenting the results of this survey, I will follow the structure, the survey structure. So as I said, in the first part of the survey, we were interested to learn about the attitudes of people to various ways of handling disputes. And here we collected data on aspects like sources of information that people rely on when faced with disputes, factors that influence preferences for certain ways to handle disputes, then people's awareness and perception of mediation, and people's perception of ODR. Let's have a look at the first question. So in our first question, we asked the participants to identify the primary source of information to help them better resolve the problem. And we provided our participants with 12 options, and they could mention any other source. And relying on the data, the top two sources of information appear to be websites or apps and lawyers. And well, perhaps the reliance in this digital age on internet is not surprising. As for lawyers, our results align with results of other studies. So if we look, for example, at the results of a Global Pound Conference Series survey, that's a survey that was conducted in 2017 and 2018, and it had more than 4,000 participants that represented different stakeholder groups. These were parties, so the users of dispute resolution services, lawyers, adjudicative and non-adjudicative dispute resolution providers, researchers, educators, and government representatives. So what emerged from that GPC series survey was that in choosing a dispute resolution process to use, parties rely on lawyers. Lawyers recommend processes that they are familiar with, but the needs of parties in terms of information about available dispute resolution options are not satisfied at this point. So, and that emerged from the question where it was asked about obstacles that parties faced when seeking to resolve commercial disputes. So when people were asked to indicate the obstacles, insufficient knowledge of options to resolve disputes emerged as a second main obstacle, whereas the first one was financial and time constraints. And that was a global result. But the researchers who conducted this survey, they also looked into the regional data. And what we found was that if you look at continental Europe and Latin America, so for the participants from those regions, the most significant challenge is insufficient knowledge of options to resolve disputes. Whereas for the rest of the world, the most significant challenge is financial and time constraints. And how do we explain this distinction? So the explanation is that dispute resolution in public courts in civil law jurisdictions is relatively less expensive as compared to other jurisdictions, and certainly as compared to common law jurisdictions. And if we speak about unfamiliarity of lawyers with mediation, we can also refer to some domestic studies conducted in Belgium. So one study, and I'm speaking about empirical studies, one study showed that unfamiliarity of lawyers and parties with ADR is the main reason for the limited use of mediation and arbitration in IP disputes. There was another empirical study in Belgium that demonstrated that although overall Belgian lawyers have a positive attitude to mediation, there are persistent misunderstandings of the process. So it is perceived as a threat to lawyers' revenue. There is fear of abuse of mediation process, and there is a concern that judges may coerce parties to mediate. And to overcome misunderstandings and meet information needs of the parties, it appears important that lawyers familiarize themselves with mediation and ADR. And in Belgium, there is actually a development in this respect. Since 2018, the Belgian Judicial Code in Article 444, paragraph 2, requires that lawyers inform their clients about ADR at all times. So that's in respect of sources of information to help resolve disputes. Now we'll move to the next question. And here we asked what factors would influence participants' decision in choosing a particular way to handle significant problems. And what emerged from the data is that cost is the most significant one. So, and perhaps this is not surprising if you look at the data from other studies. And again, I can refer in this respect to the GPC series survey. So their time and cost efficiency to achieve outcome emerged as the most influential factor for the parties who are involved in commercial disputes and who are choosing the type of dispute resolution process to use. Then perhaps we'll be coming to the most interesting part, that's in respect of mediation. So we tried to gauge the familiarity of our participants with the concept of mediation. And we asked them to choose the most appropriate definition of mediation from the three suggested. So you may see all three of them on the slide. And many participants appeared to be familiar with the concept of mediation. Most chose the right definition. So that's 58% of the participants who chose the right definition. And we preferred using, so, and that's the definition on the left, so the first definition that you see on the screen. And we preferred using this definition instead of the one that is contained in the Belgian legislation. So Belgian legislation since July 2018 contains a definition of mediation. Before there was no definition in the law. And I will just read the translation of that definition for you. So that definition is contained in Article 1723, paragraph 1. It says, mediation is a confidential and structured process of voluntary consultation between conflicting parties with the participation of independent, neutral, and impartial third party who facilitates communication and attempts to lead the parties to work out a solution themselves. So our primary motivation in including the definition as you see it on the screen was to avoid using any legal jargon and technical language. So we preferred to go with a definition that is expressed in lay terms. What we did next was that we listed advantages that are often presented as reasons to resolve disputes from mediation, and we asked our participants which of them would make them consider mediation the most in the event they were faced with a dispute. And the respondents regarded saving money as the top reason, so 56% chose that option. So they regarded saving money as the top reason to consider mediation. And this was followed by better resolution possibilities and the possibility to express personal views. And if we look at the existing empirical data, we would see that it, and I'm referring to empirical data outside our study, it demonstrates the economic benefits of mediation. In particular, I can refer to the 2011 European study, the title of which is Quantifying the Cost of Not Using Mediation. So that study revolved around the question, what is the cost of not using a two-step mediation when court procedure in Europe? And what the researchers in that study did, they assessed the impact of mediation on length and cost of the resolution of disputes in correlation with the expected success rate of mediation. And the study found that the higher the success rate of mediation, the shorter is the duration of the dispute resolution proceedings. And the study concluded that mediation is a time and cost effective dispute resolution mechanism at almost every level of success rate. And what the study also attempted to do was to calculate a percentage success rate at which mediation stops being a time and cost effective option. And the EU break-even point for the time saving is 19% of mediation success rate, and for cost saving is 24% success rate, which is actually quite low. And what the researchers in that study also did was that they tried to calculate the average cost to litigate and to mediate within the EU. And their conclusion was that on average it costs about 10,500 euro to litigate in the EU and about 2,500 to mediate in the EU. So when mediation is successful, European citizens can save up to 8,000 euros per dispute. And of course, if mediation is successful, this alleviates litigation costs for governments as well. So we were interested not only in reasons to choose for mediation, but also why people would not choose for mediation. So what we did in the next question, we listed reasons. Some people are uncomfortable with mediation. And we asked our participants which of these reasons would make them most uncomfortable of resolving the dispute from mediation. We gave our participants 9 options, and they could add any other reason. And the top reason why the participants would not opt for mediation is that mediation is only possible if the other party is willing to participate. And interestingly, the gap between the first top reason and second top reason is quite huge. So the first top reason, so that mediation is only possible if the other party is willing to participate, was chosen by 66.3% of the participants, whereas the second top reason was chosen by about 23% of the participants. And our assumption is that the top reason might signal the demand for more incentives requiring parties to give a try to mediation. And this result is quite notable because the Belgian legislation, so Article 1734 of the Belgian Judicial Code, already allows a judge in certain stages of the proceedings to impose mediation, provided merely just one party agrees to it. And that's a provision that was introduced in the Belgian legislation in July 2018. And the situation before July 2018 was that the judge could order mediation only upon joint request of the parties, or if all parties would agree. So it seems that, well, the step taken by the Belgian legislation, by the Belgian legislator, indicates an intention to create stronger incentive to mediate. But given the result that we received for this question, we wonder whether the incentive is strong enough. So that's the question that we ask. But of course, the debate over incentives requiring parties to mediate goes far beyond Belgium. It has been held at the EU level since the adoption of the EU Mediation Directive. So in particular, in 2011, the European Parliament assessed the use of mediation in different EU member states, and it found that even the top performing countries in terms of mediation experienced 2,000 or fewer mediations per year. Concerned with this limited uptake of mediation, the European Parliament commissioned in 2013 another study, that's Rebooting the Mediation Directive study, and the result was quite similar. So it showed that mediation remains largely underutilized. And in 2016, all available statistics continued to show that on average, mediation is used in less than 1% of the cases in court, except for Italy, where mediation plays a highly significant role in effective resolution of disputes in about 15% of civil and commercial cases due to the requirement of the initial mediation session. And that's a so-called opt-out mediation model. Whereas in 85% of, well, in the remaining 85% of cases that apply opt-in mediation model, the use of mediation remains extremely low. And the rebooting study actually called for the modification of the mediation directive. So the call was for regulatory intervention to introduce mandatory mediation in a mitigated model, at least for certain categories of cases. But so far, no changes to the mediation directive have taken place. And it appears that the member states who are interested in effective mediation policy should try to analyze the regulatory framework of mediation in other countries to identify policies that work best. And I'm moving to the next question. So we were also interested whether our participants would prefer going to court or using mediation to resolve disputes in particular areas. And what we found was that the participants preferred mediation to resolve disputes within their family, with someone at the workplace or with the employer, with a neighbor, and with someone who is very emotionally invested. They were also in favor of mediation to resolve disputes that involve a small amount of money and simple factual or legal issues. However, our participants indicated preference for courts if disputes involved a large amount of money, IP or copyright issues, or complicated issues. So it appears that our participants have formed an opinion about unsuitability of mediation for certain types of disputes. But of course, this perception might not be in line with actual mediation practice and wider mediation experiences. And here I can refer to a Dutch study, that's a relatively recent Dutch study of 2019, and it's called Dispute Resolution Delta. So the researchers involved in that study, they inquired about experience of problems among the residents of the Netherlands. And they were interested in a period over 2015 to 2019. And this study involved more than 3,000 participants. So one of the results of that study was that mediated disputes were often serious, involving a lot of money and not easily resolved. Moreover, mediation is hailed as a process of choice for IP disputes that often involve complex IP legislation, technological and legal issues, and reportedly, mediation is actually quite widely used for resolving IP disputes, at least in the United States. Then we were also interested in the level of trust in mediation. So how comfortable our participants would feel with resolving their problems and disputes via mediation. And more than half of the respondents reported that they would feel comfortable resolving the disputes via mediation. So that's about 54%, while only about 10% indicated that they would feel uncomfortable about it. Then we asked what would make people feel even more comfortable resolving disputes via mediation. And the top two factors were that if they know how to find a competent and trustworthy mediator, and if they have more evidence of mediation's effectiveness, so the likelihood of reaching a settlement. And we found particularly surprising the result about finding a competent and trustworthy mediator. Why? Because so in Belgium, we have a Federal Mediation Commission that regulates the profession of mediators and keeps an updated list of accredited mediators. So there is a nationally recognized group of mediators who are appropriately qualified and skilled, while the information about them is publicly available online. So it is easy to go online on internet and find appropriately qualified mediator who is accredited by the Federal Mediation Commission. However, this seems to be insufficient for ordinary people to know how to find a competent and trustworthy mediator. At least that's how it appears to be the case from our results. Then we were also interested to learn about the level of trust that people have in online dispute resolution. And of course, online dispute resolution can be defined in numerous ways. And the way it was defined in our survey was that ODR stands for the use of technology to resolve disputes through methods like negotiation, mediation, and arbitration. And here, contrary to the situation with mediation, where more than half of the respondents reported feeling comfortable about resolving their disputes via mediation, here our respondents appeared to be undecided. So in particular, about 25% indicated they would feel comfortable, whereas 27% indicated that they would feel uncomfortable, while 48% chose neither comfortable nor uncomfortable option of an answer. And when we asked what may increase the trust in ODR, the top answer was having more information about ODR. So that's the core in increasing trust in online dispute resolution. And finally, we asked our participants which of the listed ICT functions, in their opinion, would be most effective in facilitating resolution of problems and disputes. And our respondents referred to the tools to support parties, so agreement templates, self-reflection documents, conflict management tools, and applications to support administrative functions like filing, data storage and sharing, scheduling, and reminder generation. So we referred to these functions as being the most effective ICT functions in resolving disputes. And for example, AI-driven decision-making was selected by only 6.3% of respondents. We have looked at one part of the results, and those relate to attitudes. Now, let's have a look at the results that relate to the actual experience of the participants. So in this part of the survey, we tried to look to collect data on the incidence of disputes among the Belgian residents, the types of disputes that they most commonly experience, the sources of information that rely on, they preferred dispute resolution avenues and outcomes obtained when resolving disputes, and the use of ICT. So the participants were asked whether they had experienced any disputes in the past 3 years. And they were specifically instructed, as I mentioned it in the introduction, to report about disputes that they experienced themselves. So in a private capacity, not problems experienced by the employers, by the business they run, or in the course of a self-employment, and also not situations when they had helped someone to resolve a dispute. And almost half of our respondents reported having experienced the disputes in the course of last 3 years. And the incidence of disputes might appear to be quite high, but if we look at other studies, so they come actually to comparable conclusions. So in particular, I can refer to a study which is Access to Justice module of the World Justice Project General Population Poll. So that's a poll that was conducted in 101 countries of the world. And that happened in 2017 and 2018. And they used a sample of about 1,000 respondents in each country. And there, the general incidence, so the global incidence of problems over the previous 2 years. So in our study, we asked about a period over the last 3 years, but in general population poll, we asked about a period of 2 years. So there, on a global scale, the same amount of participants responded that they had experienced a dispute. So the results of our study are comparable to the results of other studies in terms of the incidence of disputes. So all further questions were asked in respect of disputes, of the disputes that people experienced. So people who had no experience with disputes did not answer any further questions in this part. We were interested to learn about the types of disputes that people experience in private capacity. And most of the experienced disputes, as per our participants, related to goods or services, family, housing, and employment. And again, if we look at the results of other studies, so I can refer again to the general population poll or to the Dutch study that I referred to earlier. So the results are comparable. So people refer to the similar types of disputes as the most frequent ones that they had experienced. Then there was another issue that we had to be very attentive to. So we tried to assess the seriousness of disputes, of experienced disputes. And here we had to rely on the existing best practices. So, and we did that to avoid being swamped with the trivial matters. So, and in order to achieve that, a good approach is to only follow up disputes that reach a minimum seriousness threshold. so following this good practice, what we did, we asked our participants, so we posed this question that you can see on the screen. We said, thinking about the problem as a whole, what number best represents the seriousness of your problem on a scale of 0 to 10? So 0 representing the least serious type of problem you could face, and 10 representing the most serious. And then we also gave some examples. In particular, we said a score of 9 might be an injury caused by an accident at work and leading to disability, while a score of 1 might be a billing error. And then, so once we asked the participants to assess the seriousness of disputes, we selected those with scores of 3 and higher. And we selected 1 dispute per participant with the highest seriousness score. And then all following questions were asked about that particular dispute. And like in the first part of the survey, we were interested to learn about the sources of information that people rely on to help them resolve the dispute. And when we asked this question, so in this part, of course, we were asking already about the actual experience of participants. So what did they do? What source of information did they rely on when they actually experienced the problem? And the data shows that most often the respondents used websites or mobile applications. And then additionally, we asked our participants whether they had obtained any information or advice from any person or organization to help them better understand or resolve the problem. And 60% of our respondents answered yes to this question. And we then asked those who answered yes to this question about the source of advice. And here the most popular answer was consulting a lawyer. So 46% of the participants reported consulting a lawyer. And the second most frequently mentioned answer was consulting a family friend or acquaintance. So this results showing that respondents relied most often on websites, applications, and lawyers, seeking information or advice to help them actually to resolve a dispute. They are consistent with the overall attitude of the participants of the survey in respect to various sources. As I explained, so I mentioned that in the first part of this presentation, that websites or apps and lawyers emerged as the top 2 sources of information that the participants reported that they thought they would use in case they would have a dispute. And so if we look at the results now about the experience of participants, it actually, they match. So indeed, people use what they say they would use. And if we look at results in respect of a source of advice, so here we have the top answer is a lawyer and then family friend or acquaintance. So these results are also comparable to the results of other studies where these 2 sources of advice emerge as the top 2 sources that people refer to when they're facing a problem. We asked our participants to indicate what of the listed options happened as part of resolving the problem. And we gave our participants about 13 options. And the data shows that most commonly our participants resorted to communication and negotiation with the other party. So that's 36%. Quite often one party went to court, that's about 21%. And mediation was used in according to 10.6% of participants. And if we compare the results in respect of mediation, in respect of the use of mediation, the rate of use of mediation that emerged from our study appears to be much higher as compared to other studies. So if I refer to the Dutch study of 2019 that I have already explained a bit about, So there, only 5% of the participants reported using mediation. And in Belgium, like in many European countries, there is no official statistical data on the use of mediation. The studies that exist, in general, they rely mostly on accounts of mediation experts who report about their own activity and experience. So, and I can refer to a specific study that has been conducted already 5 times in Belgium. And that's a study organized by, with the help of a private sector, so by a mediation organization, Mediation, with the support of a Federal Mediation Commission. So that's a survey, it's called Mediation Barometer. And it's a survey that is organized among mediators who are accredited by the Federal Mediation Commission. And so far, it has been organized 5 times in 2012, 14, 16, 18, and 21. And even if we take the highest number of mediations per year, and that was in the year 2020, and the number there is about 7,000 mediations, it still constitutes only 0.7% of cases that go to court. And our assumption at this point is that perhaps our numbers are higher as compared to other existing studies in Belgium, because we are asking our participants, or we asked our participants to report about the experience with dispute resolution over a period of 3 years, whereas the existing Belgian studies, so this mediation barometer among mediators accredited by the Federal Mediation Commission, so they usually ask for input, or they gather data on 1 year period of time. Those who used mediation, so we asked them a follow-up question about the reason for using mediation. And most often, those who use mediation referred to saving costs, which was followed by saving time, that the dispute was simple, and to reestablish a dialogue. And this result, so saving costs, this result about the top reason for using mediation is consistent with the overall perception of our participants that saving money is the biggest mediation advantage. We also asked our participants about the use of ICT, so whether the process was conducted using ICT. And so here are listed various processes that the participants reported having used. In well over half of the cases, in respect of all the processes, the process was conducted using ICT, either entirely or partially. And finally, the participants were asked how the problem outcome was ultimately brought about. And here we offered our participants about 12 options, and they could indicate any other outcome. And as you can see from the chart, most often the dispute outcome was brought about by a court judgment. So that's 21% of the participants who reported this outcome. In 15% of cases, the outcome was brought about by a mediator, and in 15% of cases, parties reached an agreement on their own. So then I will proceed to my conclusion. So what has been presented today is the result of an initial analysis of the results, and what we found is that the study that we conducted, it appears to be the first study on mediation that collects data from the general population. So the existing studies in Belgium, they focused on the perspective of mediators, not on the perspective of ordinary people. So the majority of our participants appeared to be familiar with mediation, but there are also misconceptions about the process. So an example would be that mediation appears to be, in view of the participants, appears to be suitable only for simple but not for complex disputes. Cost emerges as a key factor in choosing a way to handle disputes and in choosing mediation. The survey emphasizes, or the results of the survey emphasize, the importance of internet and lawyers in choosing a dispute resolution path. Perhaps more information should be made available online, and there must be ways for lawyers to be stimulated to learn about mediation if they have not learned about it so far. And then the top reason why people or the participants of our study reported that they would not choose for mediation. So, and I would remind the audience that mediation is only possible if the other party is willing to participate. So does this signal that there is a demand for more rigorous incentives requiring parties to give a try to mediation? So it would be interesting to hear the opinions of people who are participating in this session.
Wow.
Also, it would be interesting to conduct similar studies in other countries to see how the results actually compare. So I thank you for your attention, and I'm looking forward to your questions and comments. Yes. Elfierini.
Hello. I also started this discussion in the breakout room, but we didn't have enough time. I would like to say that Greek law system followed the Italian model. Yes. So mediation is not completely voluntary, but it is somehow mandatory for specific cases. It is mandatory to pass from initial mediation session, and only if this session is failed, then go to court. Otherwise, if the parties skip this step, then if this is skipped, then the claim would be inadmissible by the court, and the case would be rejected for typical reasons. So I would like to ask your opinion, because you have done a very descriptive survey. I would like to ask you, I don't know if this in Belgium is compulsory, but I would like to hear from you and from other mediators, how do you assess this regulatory framework? If you think that this semi-mandatory, semi-voluntary regulation, if this enhances the awareness for mediation and as a result, mediations to be done, or that this abolishes the voluntary character of mediation and make it compulsory, and this make people more negative for mediation.
Where you come from? Greece.
Oh,
thanks.
I'm coming from Greece, yes.
Okay, thanks.
If I may comment on your question, I just recently I've been reading an article of I think of someone who is coming from Italy as well. So that's Giuseppe De Paolo, and he's someone who has been involved in numerous European studies on the use of mediation and on the ways to promote mediation. And so his conclusion is actually that he discusses the issue of culture, so whether culture matters in how mediation is used. And his conclusion is that the primary issue is policy. So there is no other way to stimulate the use of mediation and to promote the use of mediation than to introduce. So he's the proponent of a opt-out mediation model. So I would agree with his position. So I think it should be stimulated, but there should be an easy way out. So I think what is happening in Greece, so it's quite similar to what is happening in Italy, because in Italy there's also a requirement of for this 15% of civil and commercial cases. So there is a requirement to participate in the initial mediation session, and then parties, well, any party can opt out of mediation. And he also speaks about psychology of people in general, that actually it's quite easy to go with the default option. So, and he analyzes it on the basis of, again, the difference between the way opt-in and opt-out models function in Italy. So, and apparently, if in case of a opt-out mediation model, so when people have to actively opt out of mediation, there many go along with mediation and proceed on that path. Whereas when people have to opt in, actually not many take that step. So that's what I could say in this respect. I don't know whether anyone else have any comment on this issue.
If I may,
Yes,
I teach in France, I teach IP, I teach dispute resolution, international dispute resolution now. But in the past, I was a lawyer and pre-trial mediator in Buenos Aires, Argentina, and mediation became mandatory before filing any lawsuit in 1996. So it's quite an interesting experience, because it goes in the same direction of to what you said, or the Paulo suggests. At the end of the day, well, laws influence and change cultures, and certainly nobody is unaware of what mediation means. Mm-hmm. Everybody knows what mediation is. There are a lot of trained, experienced mediators, lawyers that are explaining mediation, and that was probably done because of the wrong reasons. Because maybe there are different ways why we would like to promote mediation, qualitative or quantitative. Maybe because we want better solutions, that would be a qualitative approach. But when the justice system, the court system is clogged, well, that's a quantitative approach. That's why it was promoted in Buenos Aires in 1996. It became mandatory, and the judges were in favor because they had too many cases. Mm-hmm. But at the end of the day, it sounds like a contradiction, but mandatory mediation work at least to install a culture of mediation and to train good mediators. Of course, there are few statistics. I share one from 2012. That's the only one I could find that suggests that this mandatory form of mediation, that I repeat, before initiating any civil or commercial lawsuit, is mandatory to go to a mediator at least twice. And the system is highly regulated, but it had worked in a way more for some type of cases than for others. It has been more successful in some type of cases. And it was also welcomed by insurance companies, because insurance companies, at the end of the day, they negotiate how much they have to pay. They know that they have to pay. If you sue them, it's because probably you have a good reason. So the lawsuit is about negotiating how much money they have to pay. They have found, my point is that there are some stakeholders that have also supported mediation, like judges because they had too many lawsuits, insurance companies because it lowered the cost of negotiating the settlement, the amount of money they have to pay. In particular, I'm talking about insurance related to car accidents that are the most common ones, and basically it's about money. So I think it's an interesting experience that shows this point that the law can change the culture, but of course, more is needed, because why is still, it works better in some areas than in others, and there's also in parallel voluntary mediations that do not work as well. It's very difficult to convince people to go to voluntary mediation, but when they have to go to mediation because they are forced to, they negotiate and they reach a settlement, which is quite puzzling. So I always remember my experience as a mediator in Buenos Aires as a very interesting exercise. When people were in the mediation meeting, it was easier to. It was in some type of conflict. It was relatively easy to find solutions. But without the law, they would probably have never gone. That's the contradiction I found. It may has to do with culture and maybe solved by legislation or by regulatory changes.
Thank you very much for this contribution. I'm wondering whether this mandatory mediation, whether it's applicable, well, to broad range of cases only, yes? Well,
everything that has everything that is private law and is about patrimonial rights. So what is left outside is labor law disputes, though there is a system called conciliation where the government is involved. That conciliation is a different type of system that we can leave this aside, but there's an alternative for labor. Certainly criminal law is excluded, and non-patrimonial aspects of family law, everything that is public policy is excluded. But everything that can be disposed by the parties has to go. It's just mandatory. Mainly all civil and commercial lawsuits before you have to go to a mediator, because unless you get some sort of document that says you went to the mediator at least twice, the judge will not receive the demand. That's how it works. So it's quite broad.
All right. Well, thank you for this additional comments. I'm afraid, and I see Emanuela raised her hand, but I'm afraid we are running out of time. So I will just check with Verena whether we could give a floor to Emanuela for her last comment.
Certainly.
All right, Emanuela, we don't hear you because your microphone, I'm afraid, is off.
My question is about the slide initial findings, because the first point tells familiarity with mediation, but also misconceptions about it. What I was telling and thinking and wondering in reality, as Italian and French mediator, is that I really was astonished by the definitions, the correctness of definitions. Because normally in Italy, if you ask what's mediation, do you know mediation? Do you know what it is mediation? They answer to you very simply is to meet together in the middle. That's the common answer. So everyone thinks about a transaction, not a procedure, a process regulated by a third. Especially what astonished me was the knowledge of the present of the third operating in the mediation. So why it happened this way? Why it happened that? Why Belgian people knows very so well the function of the third?
Well, it's I think, well, they would be the best to ask, but I would commend the work of a Federal Mediation Commission, because so they've been doing, I think, a great job in promoting the knowledge about mediation. Every year they organize mediation week. So, and during that week, they actually organize lots of activities in all parts of Belgium. So they bring together local mediators who organize sessions for general public as well about mediation. So I guess that might be part of the explanation that people are familiar with mediation.
That's for me was very interesting.
Mhm. Thank you. So thank you very much, everyone, for your input during this part of a session. I learned quite a lot from you, and I hope there was something useful in the results that I have presented. And I would just finish by showing the team that conducted this study, this survey. So there were at least 5 of us. Professor Stefan Rutten, Professor Beatrice van Leverge, myself, PhD researcher Rachel Beretta, and Johannes Sil, who will be taking over the floor now. So he's a representative of Conflicool, who joined the forces with us in designing and conducting this study.